Good afternoon, everyone. Welcome to this month's England and Wales Property Forum. We have had a few questions sent in so far, which is brilliant. However, please do keep sending them in and raise any topics you would like Ian to talk about today. I must stress that this is your forum, so ask anything via the chat, or if you'd like to use the microphone, please raise your hand. I will be working behind the scenes, as usual, giving people access to contribute. We've had a brilliant increase in the amount of requests for face-to-face meetings and training, which we have been running roadshows to cater for this. I will hand over to Ian to tell you more about the next one and to start the show. Thank you.
Freddie, a delight. Thanks very much. That Mr. Smith, you know, he's not cut out for introducing webinars such as this, Freddie. So I'm delighted that you've taken over the mantle. It's really lovely to work with you. Good afternoon, everyone. Welcome to the webinar. I hope you're all fit and well and happy. Easter has been and gone, hasn't it? The children are now back to school or back up their chimneys where they belong, and we can get on with some conveyancing. What we're going to do this afternoon is talk about a number of issues, but as Freddie mentioned, it's your event. Of course, Stewart Title are very kind to sponsor the event, but at the end of the day, we can talk about any topics that you like. We can go off on a myriad of different directions, but we've got some things to start the ball rolling this afternoon. We are recording today's event. If you want a copy of the recording, I'm sure Freddie and the team at Stewart Title can make that available to you. And before I sort of start looking at the topics that I would like to look at to start things rolling, again, do talk to Freddie, Robert Kelly, Stephen Smith, and the team at Stewart Title if you have any needs or any requirements or any questions about title indemnity insurance. As I'm sure you're aware, Stewart Title have a sort of a basic level of online service that they can provide, but they also have got a number of experts, underwriters, guys such as Freddie and Robert, etc., all of whom are there to assist and help. And they have underwriters that I'm sure have encountered just about every type of insurance or risk that you could think of in connection with residential conveyancing, and therefore there might be something that's new or novel to you, but if you spoke to Freddie or Robert or any of the underwriters, they may have encountered this sort of thing before. They may have a product that automatically fits the bill. Alternatively, they may be able to design something for you. Freddie was mentioning roadshows, etc., and we are doing a roadshow. The next one is the 30th of April in Ashford in Kent. If you'd like to come along, we are offering a sort of cracking deal with regard to tickets. There are a few available. Message me, send me an email if you'd like to come along, and we can organise that for you. But it's lovely to see you in person on the 30th of April down in Ashford. So, useful websites. I always refer to these sites. A number of things just to draw to your attention if I can. Firstly, as far as the Association of Residential Managing Agents is concerned, they were supposed to generate some guidance for LPE1s for landlords, new revised guidance. That's not available. They also used to have guidance for clients about the state rent charges, and that's been removed from the site. I don't know why, to be honest with you. I do mention the Legal Ombudsman's website, well worth looking at to see what sort of complaints the Ombudsman's receiving. Remember, residential conveyancing is a hotbed of complaint, and it's nice to keep abreast of what sorts of complaints the Ombudsman is encountering, and also well worth cross-checking your complaints procedures with regard to what the Legal Ombudsman consider to be best practice. Property Law UK, our monthly publication sponsored by Stewart Title, the April edition will be combined with, or will combine lots of interesting cases, etc. And there's also a BSA update special edition, which is coming out in April, which again is free. So if anyone's interested in that, let me know, we can organise that too. So topics, number of things. Firstly, some interesting cases concerning undue influence and mortgages just recently. Don't know if you've seen it. I'm just going to dig out the case name if I can while I'm waiting. But do be aware of the fact that as a practitioner specialising in conveyancing, there could be circumstances where you are concerned about the potential for undue influence. For example, husband and wife, partners, etc., buying a property. Or in particular with regard to remortgage, there could be a situation where one of the parties to the remortgage is deriving considerably more benefit than the other. Really, the issue of undue influence sort of harks back to this idea about knowing your client. And remember the point that I frequently labour, there's no such thing as a collective client. These are individuals that you are dealing with and that you need to know. So a lot of firms, particularly where they're dealing with clients on a sort of virtual basis or a distance basis, are sort of removed from getting to know the client. But the Law Society guidance, CQS, and most professional bodies are concerned that you get to know your clients and that you are able to predict or to be aware of the potential for risk relating to undue influence. So I'm just going to dig out the case that I was looking at over the weekend that dealt with this. And that case is, if I can find it, a case called One Savings. Yeah, here it is. One Savings Bank against Waller Edwards, 2024 decision. A really interesting case in which the court, on the facts, didn't really generate anything that was too exciting, but was a really useful case for just highlighting how the courts look at undue influence, and in particular, how they attach constructive notice to lenders. So again, if I just take you through it and just show you sort of some of the things that the court had to say, what they did is divide up cases involving undue influence into three types. Surety cases, non-commercial transactions where a wife stands surety directly or indirectly for a husband's debt, or where one borrower guarantees the debts of the other or of a company. In cases such as that, the lender would normally have constructive notice of the possibility of undue influence by the other and would be put on inquiry. And Barclays Bank and O'Brien, of course, and Ettridge are the cases that are important for that one. The court then said there are joint borrowing cases where a loan was taken out for the joint non-commercial purposes of two borrowers in a relationship, whether husband and wife or not. And the court said that in circumstances of that type of transaction, the lender wouldn't normally have constructive notice of the possibility of one borrower exerting undue influence over the other. But then the court, and it's the Court of Appeal decision, said you've also got hybrid cases where you have a situation in which the borrowers sought a loan partly for their joint non-commercial purposes and partly for the benefit of one borrower only. So in those circumstances, is a lender put on inquiry or not? And what the court said is where you've got a hybrid scenario, a creditor would be put on inquiry when a wife was offered to stand as surety for her husband's debts by the combination of two factors. The transaction was on its face not to the financial advantage of the wife, and B, there was a substantial risk in transactions of that kind. So really interesting case. I don't know if you've seen it. I will be writing a full report on this edition of Property Law UK. And if you ask me kindly, I'm sure I can send you a copy of the notes that I've made relating to it. But it's just a nice sort of aid for practitioners to think, you know, when I'm doing a risk assessment, is this the type of transaction where I've got to be alive to undue influence? Are there systems and processes that we as a firm or I as a fee earner can put in place to ensure that I'm not subject to any vulnerability with regard to claim? Because there is a risk that where a lender has constructive notice of undue influence, the lender is then unable to enforce the charge against the borrower. And in those circumstances, there's a risk that the lender then looks at you and your professional indemnity policy to determine whether or not there is some liability that can attach to you. So interesting case worth talking about. The other case that I looked at, I'm just trying to find that one because another case I've just been working on over the weekend. Bear with me a moment, I'll find this one for you as well. This was a case, I think, concerning Insurance rent in service charge. Yeah, it is. Again, an interesting case. Don't know if you've seen it, called Octagon Overseas Limited against Cantlay. And again, what you had here were insurances being incorporated in the service charge, and leaseholders bleating because they were saying, well, hang on a minute, you're asking us to pay within service charge a commission that you receive and an expense which was a third-party insurance broker, their fees in connection with arranging the insurance for you. And leaseholders were saying, that's not reasonable, we're not liable for it. First tier tribunal said, you're right, Mr. Leaseholder, you're not liable. Upper tribunal said, look, we've got to look at the lease, and the lease was so widely drafted with regard to obligations of leaseholders to pay insurance premium and defining insurance premium as not just including the premium, that the upper tribunal was prepared to reverse the decision of the first tier tribunal, but then said, I have a discretion, or we have a discretion, as to the reasonableness of the cost, and we deem that some of the cost is unreasonable. So again, you had a Pyrrhic victory for the landlord, a victory for the leaseholders, in that they weren't required to pay all the service charge that had been demanded. Okay, so TA6s, what do we think about the new TA6 form? Can I tell you that I haven't encountered any real positivity whatsoever? Zara starts the bidding with its bonkers. I think Zara, that's probably one of the most polite types of response that I've heard relating to it. If you look at LinkedIn, there is various levels of criticism, less and less polite, really, as against the Law Society. The first question I would like to put to you is, do you think the original TA6 required revision? You did, Zara, and I read it, and I'm doing a webinar on the TA6. Yeah, I thought the original TA6 was fine. And Zara and Lara, I'm going to come back to your point now because I think it's really important. At least with the existing TA6, there was a degree of clarity, wasn't there? On the basis that, hey, the client is left on their own to complete it. Yeah? And now what we've got with the new TA6, I think, is a nightmare. And the nightmare is this. If you look at the TA6 form in its revised format, there are what are regarded, I think, via the Law Society as help or guidance for the seller completing the form. So there's reference to links or reference to guidance or reference to, you can consult your solicitor for advice. Well, that runs completely contrary to the principles with regard to the TA form and CQS and the conveyancing protocol. Namely, that the client is expected to complete these forms in isolation. And as I have maintained throughout, your job as a conveyancer is to check what the seller says when they've completed the form and highlight to the seller where you think the information that they've produced is defective or inconsistent with what you know from your file. Zara mentions another point. They've gone into too much depth on things that are discoverable by searchers, yes. Liability on estate agents should be, yeah. So I think there's a sort of a mix of this sort of early disclosure of information from an estate agency perspective. Yeah. And I think that's the point Zara makes. Yeah. And this point about, well, what do I do? Okay. The expectation with regard to TA forms is that the clients fill them in isolation. My job is simply, when they've been completed, to point out to the client that perhaps this answer is defective or perhaps they've got this wrong, etc. And the question I would put to everyone is, okay, so what happens where I know the client hasn't sought the guidance that the new TA form suggests that the client should obtain before they answer the question? So am I required to actually give the client the link, print off what the guidance is and send it to the client when they're filling in the form? What happens when the client hasn't referred to the guidance? Do I say, look, go back and have a look before you answer that question? And then I ask, well, am I being paid enough to do that policing or babysitting? So let's just go and have a look at what people are saying for a moment or two. Mark, hi, Mark, by the way. Hi, Nicola, as well. Yeah, so Lara agrees with me. We can't really leave our clients in. It's like the TA7 form, Lara. You can't let a seller client that selling a flat or apartment that has BSA issues answer a TA7. They just can't do it. Nicola, yeah, conveyancing is different. It required... and that it required the form to be doubled in length. I'm not that bothered about the size of the form, Nicola, other than the longer the form, the less likely the client is going to sort of answer the question sensibly and seriously, and the more time we're going to have to spend checking. I don't have an issue with how long the form is. My issue is if you're saying to the client, before you answer this question, or if you're unsure as the answer to this question, look at that guidance. That worries me, okay? And it worries me even more because William Sindel PLC against Cambridgeshire County Council, Rosser and was it Pacifico, the recent case. Courts are saying, if you answer this question, you've got to undertake reasonable investigation before answering it. If you don't undertake reasonable investigation and your answer is wrong, you're liable for misrepresentation. That seems to be the message from Rosser and Pacifico. I hope you've all seen that case. And that's nothing new. If you look at William Sindel PLC against Cambridgeshire County Council, although the facts of the case I don't think really justify the point. The point seems to be that a sort of legalistic reply implies that you've carried out reasonable investigations before the reply has been provided. So Mark's, I think that being a little bit political with a small p. So Law Society have done something. Yeah, perhaps. I don't know. I have to put my hand up. When we're writing the Building Safety Act book, I was told that the revision was going to be published in March, and I was also told that there wasn't anything in it really that would impact on the TA7 form. But certainly I agree with you, Mark, that the profession seems to say we don't like this at all. I can understand it why. Yeah, but the point there is we've got the TA7 form, haven't we? Yeah, it's a problem, isn't it? So I think what we've either got to do is we've either got to say, right, forget about what we said in the past. You do this in tandem with your conveyancer, yeah, or we start again. And I agree, Zara, there are some questions where there isn't the facility to provide an appropriate answer. I agree with that point. Lara spent on the just going through the form of the regulars. Yeah. All right. So, Lara, question: do you charge your client extra for that hour? And anybody else? Yeah, I think that's a fair point as well, Zara. It is seller beware, isn't it? Well, if we're doing extra work, and I can't see how we can't do extra work, then we should be charging more. The only thing I think we could do is in our retainer, say to the client, the seller client, you're going to be required to complete a TA6, TA7 form. Before you answer those questions, you must refer to the guidance that is referred to, and or if you're going to refer to us to assist you, then there's an additional charge. That's an interesting question, Sue. Licensed conveyancers, we don't need to use them, but has anyone encountered any resistance from solicitors saying, no, you've got to use them? Yeah, thanks for Zara. Yeah. All right, you haven't tried it yet. Anyone else encountered, pushback when you're saying we're not using the new form? And anyone encountered the problem that Lara was saying about the fact that she's had to do some additional hand-holding and the cost implications? Well, that's the point, Mark. I think if you're saying we're going to charge extra to answer the questions where the form is saying consult us, and I think if you say you must look at the guidance before you answer the questions where the form requires you to look at the guidance, then that might help. Right, so you've had it already, Laura. Okay. Has anyone asked insurers what their view is? Because I think insurers are not going to be happy with this. Has anyone heard anything from any of the brokers or the insurers? Because, you can see a seller who gets stuffed with a misrepresentation claim thinking, well, what do I do here? And the obvious thing is, let's have a look at my conveyance or solicitor that acted for me on the sale and see if they gave me the appropriate warnings. Thanks for that, Zara. So anybody else on this? And then the next question, and I haven't, to be honest, I'm going to be brutally honest, I haven't looked at it because I haven't had time. What do you think about this thing of upfront information and sort of HIPS 2, etc.? What are you finding from your introducers? What are you finding from the market generally about this idea of upfront information? All right, thanks for that, Christopher. So 25th of June is the sort of the trigger date, is it? Wasn't aware of that. Thanks, Christopher. By the way, I hope you're fitting well. So again, on this, from information, what are you finding? Yeah, right. Yeah, I mean, it's sort of tinkering, isn't it? I think it's tinkering with the system. And it's just like home information packs, we'll sort of dilly and dally for a bit and then think, oh, right, it's not working. Right, so Mark, clients will choose not to pay. Let's just look at what Mark has to say first. Then I'll come back to you, Lynn, and I'll come to you, Eleanor. Yeah, I think again, Mark, I say to people, look, you've got to warn clients about the dangers of misrepresentation. And also, if they deliberately lie with a response, you've got to warn them about the potential for committing a criminal offence under Section 2 of the Fraud Act 2006. But I think you do have to, well, Mark, let's put it this way. I think we're not stepping in, we're stepping out. When we're scoping the retainer, we're telling the client. When the form comes in, we're doing that check. And again, I would say we warn the client. And then when we're proceeding towards, completion, etc., again, we warn the client about what they've said. Lynn, hi, Lynn. On the property, it's 30 long. Clients have to give a lot before completing. Yeah, they do. They do after that. Yeah. So, and is there not a bit of duplication there, Lynn, as well? I don't know if you've had that, but I was speaking to someone who said, this is just, we're regurgitating information. Has anyone got a system whereby property information questionnaires can have data migrated from it and populated TA6? Anyone seen anything like that? you talk to some of these people, they're they've got all sorts of ideas on that. On that front, have you all seen Orbital Witness? Do you know Orbital Witness? Have you seen Orbital Witness? They're really at the forefront of this, which is quite interesting. Eleanor, hi Eleanor. One of our agents has said they're really worried about buyers being put off by things they don't understand, and agents aren't qualified to advise, so the pool could reduce with this. So they're saying, right, that they think that it'll sort of potentially stall the market rather than boost the market. Yeah, Eleanor, I've had that a few years ago with commercial leases. We had a client, a landlord, and we had 2 sites. And on one site, because we're business lease code compliant, we were saying to tenants, unrepresented tenants, tell us what you want. We're lovely landlords, we're friendly landlords. You tell us what you want in your leases. And in the other development, we said to tenants, unrepresented tenants, there's the lease. Doesn't matter what you do or who you instruct, we won't agree any variations. That building let, the units in that building let far more quickly than the building where we said, what do you want? And the reason was, if you say to someone, what do you want? And they don't know, panic. They're unrepresented. They're not going to instruct solicitors at that stage. The whole reason is they're a startup, they can't afford it, etc. So they're not going to go run to agents or solicitors to assist. On the other scheme, it was a question of, well, I've got a lease, I'll read it. I may or may not make a lot of sense on it, but at least I've got it, and I know that if I've read it and I'm happy with it and I sign it, off we go off into the sunset. Yeah. 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 Thanks for that, Zara. Surely clients will need to check the response on approval and refer back to the upfront information given. Yeah, to make sure. Yeah, they are. Yeah. Yeah. Okay, Zara mentions the BSA, and again, just to ask the question, is anyone now dealing with BSA related work? The last few conferences I've been at, people are just saying, no matter what, no matter the Law Society guidance, no, we're not. Yeah. Hayley, you are. Okay, thanks for that, Hayley. Right. And is that a change, Hayley, or have you been acting on BSA related matters for a while? Eleanor's still nervous. So, right, we talked about the Law Society guidance in the past. Has anyone read it? Yeah, Nicola. And? Yeah, it's naive. Well, yeah, it doesn't help, I don't think. It generates more questions. And I think that's the point, isn't it, Nicola? So we were all hoping that Hay would have the definitive article that we can utilize and enable us to act. We ain't got that at all, unfortunately. And I haven't heard, Zara might know, I haven't heard and would expect to have heard if there was any plans to revise it. Yeah, well, Zara, you mentioned the developer pledge or the developer remediation contract, Zara, right? And the question that I haven't got the answer to is, all right, Persimmon Homes enter into the developer remediation contract with the government. So Persimmon Homes are saying, if there's any remediation work for relevant defects as defined under the Building Safety Act, we will pay for it. Okay? Well, what happens if they don't? Or what happens if they can't?
Well, this is the question. Oh, sorry
to
interrupt you. This is the question we've been asking, because it's, even though I actually had another solicitor come to me and say, reject for me. And I just went to him, no way, Jose. And I explained to him the issues that even though he thought he was buying with leaseholder protection, if you've got 8 flats in a building and 6 of them are qualifying leaseholders, where is the landlord who may not have, may not be the original developer going to get the money to fix the building?
No, he's not. Impossible. Quite right. Quite right.
And so we're going to end up in a conveyancing stalemate whereby they know what needs to be done, but they've not got the money to do it. Are the mortgage lenders then going to turn around and say, well, actually, we're not prepared to take the risk, especially if somebody could get landed with a big bill? You know, these leaseholder protections are not guaranteed. And, you know, the fire safety issues, the ladders don't go high enough. I'm telling people, get your own ladders, get out the window. You know, I don't want crispy clients. You know, if there's one way in and one way out, don't count on being rescued. You know, the fire brigades, it stems back to a planning issue that the planning council planners are not allowing enough space on the roads for fire engines to pull up alongside it. So by the time they get all the hoses connected, they then have to ring the water authority to turn the pressure up to put the fire out.
Yes. Yeah, I know it's a nightmare. It's a nightmare. So just to go back to this point then, okay, on the developer remediation contract, right? The thing I can't get my head around is if I'm a leaseholder and Persimmon Homes have entered into that contract with the government, but then Persimmon Homes say we're not paying out for this remediation work, or we can't, as a leaseholder, what right of redress have I got? Can I sue Persimmon Homes? I don't know. It's certainly not in contract. You know, does the government have some form of fund that pays out? Yeah, Zara, exactly. But it's all right saying pursue the developer for remediation contract orders, but there's the cost of doing that, and as far as remediation orders are concerned, it's not a simple area of law. You know, and yes, say contribution orders, it's not a simple application of the law. It's quite complex. The only saving grace is there isn't much vulnerability as to costs with regard to that application. That's the only saving grace. So anyway, going back to this point then, Haley's saying we've select fee-earners, lots of training, a working group, client guides, etc. Yeah, retainer important, report on title, Haley, important, and charging extra for the work that you do, if you can. But yeah, I mean, there are some firms that are now biting the bullet and getting on with it, but we haven't seen since the Law Society guidance floodgates and people saying, right, we're open for business anymore. Right, I'm just going to have a look. Before we talk about rent charges, does anyone else have any burning issues at the moment? Has anyone, I tell you what I was going to ask, and I forgot to mention last time, has anyone had an application to cancel or modify a restriction refused? Because if you look at the the Land Registry's guidance on restrictions, it was altered in November last year. And in essence, the suggestion from that guidance is that you should be asking the Land Registry to disapply restrictions, not cancel or modify them. I just wondered if anyone had made an application to cancel or modify a restriction and the Land Registry had refused it as a consequence of that change. Okay, while I'm doing that, yeah. Right, Haley's asking a question. Schedule 8 cladding provision. As it doesn't mention relevant defect, it's thought to go beyond the 30-year period. Well, I can answer that question, Haley. We just don't know. Unless and until we get a first-tier tribunal or an upper tribunal decision. Difficult to, paragraph 8 of Schedule 8, difficult to say. My thought is that it must relate to relevant defects. Because the remainder of Schedule 8 does, doesn't it, Haley? But Stephen's right that there's a potential there that it could go beyond 30 years, potentially. But who knows? It's like a lot of this, and again, I mentioned this to you before. The first-tier tribunal is dealing with a lot of cases involving the BSA, and the litigation invariably arises from confusion relating to the Act or the regulations. And what the tribunal says is go back to first principles. What's the purpose behind the act? The purpose behind the act is twofold. One, to make sure that those that are responsible for defective works that now require remediation pay for it. And two, that leaseholders are the last resort with regard to payment. But the other point, from a practical perspective, Hayley, with regard to your point and Stephen's point, is that what are the chances of recovering from contractors relating to work that was more than 30 years ago? Right. I haven't seen that case. Has anyone else, Zara? I'm going to take a picture of that. I'm going to have a look at it and dig it out, because that's interesting. Thanks for that, Zara. But yeah, ground rent. And the other point on ground rent, I was talking to someone about this morning, where you've got a new lease with no ground rent within it, do watch your service charge, because I am seeing landlords imposing a standing charge management fee for service charge. And I'm thinking, well, all they've done is just said, well, I can't recover ground rent, so I'll just put a figure in as a standing charge for management and recover it via service charge. So I'm going to have a look at that case, Zara. So I'll just take a photograph of it and have a look at it later. So thanks for that. Okay, right. Now, someone sent a question, I think, this morning about rent charges. And there's a number of things to note with regard to estate rent charges. Firstly, there are two types of rent charge. What I would class as a traditional rent charge, which are going to be abolished in 2030. And with a standard old-fashioned form of rent charge, you do know that you can buy out the rent charge. And you can also have it apportioned by application to tribunal. As far as estate rent charges are concerned, they are not abolished and they can't be bought out. And the problem with an estate rent charge is that you can have an estate rent charge on both freehold and leasehold properties. Of course, you're encountering them in the main on freehold properties, and developers are using estate rent charges more and more as a consequence of being required to enter into conservation covenants as part of planning conditions. So they're saying you can have planning, but you've got to preserve some ancient woodland or heathland or whatever that's in the vicinity of the development. And developers saying, well, if we're going to have to pay for that on an ongoing basis, we're not going to pay for it. We're going to have an estate rent charge for it. Or you're seeing sort of gated developments where roads and footpaths are not going to be adopted. Or, and again, I've just been doing some work on this recently, you have a situation where the Highway Authority is refusing to adopt roads and footpaths because of unusual non-standard design, unusual materials, etc., being utilised. So they're saying, well, we don't know how much it's going to cost to repair and maintain that footpath or that roadway, given the materials that you've used, so we're not going to adopt it. What's the position if you have a developer that's saying, I'm not prepared to vary my estate rent charge? And you've got a lender saying, well, we insist on it. Well, the point there is, unfortunately, if the developer, you can't compel a developer to remove an estate rent charge. You might have a situation where a developer agrees to additional clauses relating to the estate rent charge that compel the developer or builder to notify a lender before any form of enforcement action is taken. You could have provision that says that the estate rent charge is only payable insofar as that it is reasonable. And you could have a situation where there's sort of arbitration or mediation in the event of dispute. Zara's got a point here. I just want to have a look. I've got one that has made a mistake. Putting two, it's a battle on to try and get the one removed on a shared ownership lease. Yeah, it is. The other thing is, and again, I don't know if this relates to estate rent charges, but where there is a rent charge payable, an old-fashioned rent charge payable, and it's not demanded, and it isn't demanded for a period in excess of 10 years if the land is registered, you can claim adverse possession of the rent charge. Has anyone seen that? I haven't known anyone do it, but it's quite an interesting academic point. I forget which the practice guide is, but you can claim adverse possession for an unclaimed rent charge. But other than that, most developers that I'm encountering are saying, well, yeah, we agree to exclude Section 121 of the Law of Property Act 1925 and this idea of a lease to secure enforcement of payment of a rent charge or a state rent charge. Where there are state rent charges, remember that the rent charge payer is not afforded the same protection as a leaseholder is with regard to service charge. The Leasehold and Freehold Reform Bill, when I first looked at it, had provision that protected freeholders in the same way that leaseholders are protected from unreasonable service charge, but I don't know how far, I don't even know whether that's still in the bill. I'm not sure, to be honest with you. Okay, so does anyone else have any other questions or any other issues? Has anyone come across any lenders that are being awkward about anything? I mean, lenders are permanently awkward, aren't they? Again, I was talking to James Balance at Maitland Chambers the other day, and he was saying, don't forget to tell practitioners that just because lenders are saying, we're not going to answer the question that you're putting to us in connection with a defect in title or indeed anything else, if you're happy to proceed, we're happy to proceed. Just because you're constantly getting that stance from a lender ought not to mean that you stop asking the question. Always put to the lender the problem that you've encountered and ask them for their view. If you do that, at least then, if there's an issue between the lender and your firm, you've drawn the issue to the lender's attention, and the lender's failure to respond might provide a defence to a negligence claim. The other thing that I wanted to ask today was, what are you finding with regard to the market? I mean, obviously Easter's a funny time and the Easter break's a funny time. Before Easter, and now we're back on the front line again. Is it what are you seeing with regard to instructions? Thanks for that, Eleanor, by the way. Right, I'll just go back to Eleanor's point if I can. They're certainly on the lead. Lenders aren't given with what is referred as part. The solicitor's referring isn't being very clear on what they're actually worried about, referring to them about. Yeah, again, you've got to go to lenders and say, hey, look, what's the state of play here? And again, be brave. Yeah. NBS. The problem with private roads and maintenance is an issue, isn't it? There is a case called Carter and Cairns, Mark, which you should always remember, which tells you about common law principles relating to repair and maintenance. But it's all well and good creating rights of way, but you've also got to deal with repair and maintenance issues. So, Sue, you're really busy in the Northeast at the moment. Yeah. Oh, okay. And what's that? Is that just across the board, Sue? So first-time buyers, top end, bottom end, everything and anything. Just looking. Yeah. Middle and top end. That's good. Zara, yeah. I'm waiting to hear from John, Earl of Lytton. I haven't heard from him for a while. Right, Eleanor, SRA, money laundering and audit booked in. Right. Yeah, on those issues, Eleanor, what I always say to practitioners is, as well as your procedures and policies, make sure that you've got evidence of revision and make sure you've got data. And it is, Nicola, yeah, the SRA going crazy on it, to be honest. But I repeat the point. It's all well and good having policies and procedures, but make sure you've got evidence that they've been reviewed and revisited, and have data, you know, about the sorts of clients you're taking on, and if where there's changes in the types of client you're taking on, you know, are you revising your procedures or policies? The SRA are, yeah, they are. It's just one of those things, are unfortunately, just goes with the territory, doesn't it? Any other topics? Any other issues? Again, I don't know if I mentioned this last time. Or Zara, statutory lease extension and shared ownership lease. Never done one, Zara. Anyone can help Zara on that one? I've just been reading a book, I don't know if I've mentioned it before, a book by a guy called barrister called Daniel Gatti. Looking at subsoil and rights relating to subsoil, so subterranean activity, etc. Quite an interesting book looking at what you do. Be careful when you're onboarding clients about objective and where the client is intent on some form of subterranean activity, extending an attic, a cellar, not an attic, or undertaking landscaping work that involves subterranean activity. Make sure either you're limiting your retainer so you're not advising, or that you're comfortable as to what advice you're giving. So that's an interesting one. Can you do a statutory lease extension on a shared ownership lease where you haven't staircased to 100%? Right, we'll have a look at that. I've got to talk to Sarah about something, so I might ask that question. Well, that's my homework for the weekend. Right, Lynn, what can you do if a private freeholder wants to charge £800 for completion of an LPE1? Ouch. The answer, Lynn, is you can't do anything currently, because the completion of an LP1 or completion of landlord's inquiries are not administration expenses. So it's something I think that the Freehold Leasehold Freehold Reform Bill should look at. I think fees for landlord's inquiries should be administration expenses, because if they are, then they should be subject to the test of reasonableness. Yeah. Yeah, you could pay under protest, but I'm fairly confident that the tribunal does not have jurisdiction to allow the reasonableness of fees that are being charged for landlords' inquiries to be tested or challenged. There was a decision of the first-tier tribunal where the chair of the tribunal said, you know, I think what the landlord has done is extortionate and unreasonable, but I'm sure the tribunal chair said, we don't have jurisdiction to order what it ought to be. I'm sure of that. Okay, any other issues then? What are we finding with regard to fees? If we're busy, are we finding that we're able to charge more? Are we not encountering any opportunity to increase fees? All our overheads are going up, aren't they? So are we able to, have we, as of April, put our fees up? Could we? What's our thinking on that front? And what about sort of fixed fees from estate agents? Are they giving us a bit of room with regard to where we're getting work referred to us? Has anyone got an agent or a mortgage broker saying, hey, let's have a look? Yeah, so so you're finding, Laura and Sue, that you're charging. Yeah, okay. Zara's still of the view that factory outfits, raised to the bottom. Yeah. Eleanor. Yeah. I mean, I always say to firms, you know, if you're winning work, or in other words, if you're buying work by cheap fees, all you're doing is distinguishing yourself from other firms on cost. And that can't be right, can it? Because all you're doing is encouraging your new client to look elsewhere with regard to his next set of instructions. And therefore, you know, you might be winning business today, but you're not winning business long term. And I think that really what you should be talking to clients about are not fees, but value. And yeah, I think you're right. Clients are becoming aware of the problems, but often what you find, Laura, is the problem doesn't arise with regard to the current transaction. It arises with regard to the sale, and that's when, you know, the fact that some shoddy work or incomplete work has been done comes back and bites, doesn't it? Yeah, Charlotte, but the Law Society don't like that at all, do they? You know, the idea of this transparency, Charlotte, is that, you know, you're giving a figure or an estimate or a quotation, and you're not putting any bolt-ons onto that at all. Yeah. Yeah, I agree with that, Mark. I've come across some factory conveyancing that isn't cheap. Yeah. But remember, Charlotte, if you can give a quote or an estimate on the basis of we're assuming this is a standard transaction, and you can revise your fees upwards if there's an objectively valid reason to do so. There's a case called Reynolds against Stone Road Brewer that enables you to do that. Thanks for that, Harriet. Yeah, fair comment. Again, you know, the problem with fees is, as I say, you know, if you're distinguishing your firm from other firms on the basis of low fees, I think that's a recipe for disaster. Oh, see, I've never heard of that one. So charging a fee for opening the file, right? Yeah, yeah, yeah. And the other point there, Charlotte, is even if you can't actually charge for additional work, I would always say let the client know that you're doing additional work. Wow. Okay, those fees are scary, aren't they? Okay. Anyone got any other issues then? Or anything that we'd like to talk about next time? Service charge. Happy to do that, Zara, for next occasion. Resi service charge. Yeah, we'll do that. Anything else? Any other topics for next time? Yeah, I think you've got to be careful, Zara, with regard to advice for challenging. You can give advice, but we could write an essay. But we'll have a look at that. Challenge of service charge. Okay. Yeah, I was told, Sue, that insurers were pulling out of the conveyancing market. They're worried about it. Sue, have you got a broker helping you, or are you just doing it yourself? Three brokers. Yeah, Zara could be. Okay. So yeah, the market has hardened, Sue. When you talk to your brokers, do talk to them about your case management systems, etc. Because sometimes, whilst case management systems won't necessarily reduce your indemnity insurance, they can sometimes make it easier for a broker to place you with an insurer. Lynn. Code Jute. We'll have a look at that next time, Lynn, if we can. Don't know anything about it, but we'll have a look at that for next time. Okay, any other points, any other issues? Well, once again, we've covered a whole raft of different things, and it's really interesting, isn't it? Really interesting. The land registry again, Zara, yeah. Yeah, I was with the land registry a couple of weeks ago, and boy, oh boy, are they getting flack. Right. Sue, LMS fees to clients. There's a disbursement. Interesting. Don't know. I'll find out, though. Well, we've got just about everything to cheer you up. Mark, there's plenty to cheer up. There's plenty of work. There's worse jobs, Mark. Honestly, trust me, there are worse jobs out there. Like it, Zara? Yeah. All right, let's have a look. Is there anything else? Zara, we can't leave it with our final comment in chat, a picture of a chimpanzee. I can't have that. We've got to have something a little bit more positive. Oh, there are definitely worse jobs out there. Not many, Jasbit, but there are a few. Yeah, there are a few. The problem is, I think, that the days of as being a profession of a conveyancer, being in the profession, are gone. It's not a profession anymore. You know, it's a service. Clients are consumers, and all of that, which has some benefits, but it has a significant number of disadvantages. Yeah. My dear old father used to say to me, it'll all work out in the end. If it hasn't worked out, it's not the end. And on that happy note, shall we finish? And all I'd like to do is to thank everyone for attending today. Once again, it's been brilliant. We've already got topics for next time. Anyone wants to come to that Ashford conference, come along. It'd be brilliant. Eleanor, a delight. We also do a commercial property one and a one for support staff if you want people to come along. Yeah, see you in Bristol, Zara. And if you've got things that, you know, as you're dealing with them during the month, send me an email or send Freddie or Robert or Stephen at Stewart Title an email, and we'll incorporate it in the next one. All right. Sue, we're going to do something in the northeast of England in the autumn. I promise. All right. Thanks, everyone. Stay safe. Speak soon. Thank you. Bye-bye.